Welcome, everyone, to the webinar on the state of play in patent licensing and predatory infringement, hosted by the Forum for Intellectual Property at the Hudson Institute. The Forum for Intellectual Property is a center at the Hudson Institute that devoted to evidence-based policymaking and promoting evidence-based policymaking in Washington, D.C. by hosting events such as this and by publishing research and other types of work product to ensure that policymakers and legislators have the information they need in order to direct the proper policy towards promoting the innovation economy on the basis of reliable and effective intellectual property rights. Today, we have three fantastic panelists. My name is Adam Mossoff. I'm chair of the Forum for Intellectual Property and a senior fellow at the Hudson Institute. And joining me today for this conversation is Jonathan Barnett, professor of law at the Gould School of Law at the University of Southern California and director of the Media, Entertainment, and Technology Law program at USC. Kristen Asenga, who is professor of law at Richmond School of Law and associate dean for academic affairs. And last but not least, Urchka Petrocevic, who is senior fellow at the Hudson Institute, along with me at the Forum for Intellectual Property and a director of economic strategy at Qualcomm. She is speaking here today in her capacity as a senior fellow at the Hudson Institute. So I'm just going to jump right in. People don't want to hear about our lengthy CVs and various accomplishments. We can all be Googled if people are interested in that type of information. So let's spend our time actually on the topic of our discussion, the state of play in patent licensing and the current state of play with respect to patent litigation and this practice of predatory infringement. So let's kick off with this actual kind of basic question. What is predatory infringement and why does it matter? Jonathan, I think I'll just direct that question to you first.
Sure. Predatory infringement, which also goes by the name of efficient infringement, also goes by the name of patent holdout. It derives from a feature of the U.S. patent system that differentiates it from most other patent systems, and has only been in place in the U.S. patent system since 2006. And that is the eBay decision. And just in a nutshell, the way that decision has been interpreted by the lower courts makes it difficult, in some cases, nearly impossible for a patent owner in those particular segments of the market, and they're significant, to have any real prospect of getting an injunction, even if they're able to defend validity and show infringement. So let's just think about that for a second. We normally think of a patent, or many people think of a patent as a property right, yet the law is such today that significant parts of the patent owning population can never secure that property right 100%. Now, why do we care about that? The reason we care about that is that when we have a litigation where the alleged infringer or the actual infringer has abundant litigation resources, there are many, many cases where it just will not make sense as a business matter for them to ever enter into a licensing agreement up front. What does this do? It compels the patent owner, again, even if the patent owner has a fully valid patent and the defendant is clearly infringing, they are going to have to spend the millions of dollars, sometimes tens of millions of dollars, in many years and possibly multiple jurisdictions in order to ever get an injunction. The last domino effect is that this distorts all licensing negotiations in the market because the well-resourced users, the infringers, are well aware of the inability of certain patent owners to get that injunction. It systematically depresses and distorts the value of IP in favor of infringers and against innovators. It's kind of a strange approach to the patent system, which is all about supporting innovation.
All right. Thanks, Jonathan. That's a fantastic framing. Kristen, why don't you tell us a little bit about perhaps some recent legal and policy developments in this space and how these are impacting predatory infringement practices? Excuse me.
Sure. So I want to build, I think, on what Jonathan gave, which was a really great start. But So it's predatory infringement, and the way I like to think about it, I'm a little more colloquial, is infringe now, pay later, but probably not. And so that's the predatory aspect of it, is that it's a purposeful decision, as Jonathan said, but it's not just a purposeful decision to use a technology, but it's to infringe a patent, as Jonathan said, a valid patent, and by choice to decide not to enter the licensing negotiations. So one of the things that Jonathan didn't get a chance to mention that I've written a lot about is I wanted to mention that the groups who are unlikely to get injunctions, the particular groups where injunctions are unlikely to be granted by district courts, although the groups are getting bigger, but the two primary groups where this happens are patent licensing firms and holders of standard essential patents. And so these are two really big parts of important groups in the economy. And so the fact that they can't get injunctions leaves them open to the possibility or the likelihood of predatory infringement, because if you know they're unlikely to get an injunction, you then can infringe and know that at the end of the day, the worst that'll happen is you'll have to pay. You won't be enjoined. And so that's a pretty reasonable risk to take. It's not a reasonable risk to take, but in the mind of the business people, it's a reasonable risk to take. And so patent licensing firms sometimes are better known as patent trolls. Don't like that name, but that's what the population likes, the popular media likes to call them. So patent trolls or patent licensing firms are firms that may not make anything themselves, but instead just license their patents as a revenue source. And the reason that courts don't give them injunctions is the idea of, well, they're not making anything, and so they'll be happy with money. And so therefore, we don't have to grant an injunction. We'll just go ahead and issue damages as a remedy for patent infringement should we find it, and they will be made whole. And that's how we get to the no injunction situation there. With respect to owners of standard essential patents, many owners of standard essential patents, or SEPs, have obligated themselves to FRAND commitments, fair, reasonable, and non-discriminatory agreements. They will license their patents on FRAND terms. They've agreed to do this. And because of that, again, they fall into that situation where when the courts look at it, they're like, well, you agreed to license these patents. You are willing to accept money in exchange for other people using your technology. And because of that, we're not going to issue an injunction. And so those are the two primary groups that fall into the situation where predatory infringement is more likely, and the reasons why it is so. And with that, I'll turn it back to Adam.
All right.
Adam, do you mind if I jump in here for a second?
Please.
I wanted to just give a little bit of nuance on actually how big that part of the patent owner population is that is really living in a kind of semi-property environment because of the inability to get the injunction. So the first nuance I wanted to add, I just want to make it clear to our audience that the patent owners in the standard setting market and the lead innovators in that market, they are not just patent licensing entities. They are licensing out technology, original technology that they have developed on a budget of literally billions of dollars a year. And these are a small handful of companies based in the US and Europe. They drive most of the innovation, not just in the smartphone industry, but as we move into 5G and 6G, we're talking about all wireless enabled devices. So that is a really big part of the market. The other group that I would add here, because I think it's fairly clear from a lot of the case law, not all of the case law, but a lot of the case law, is that if you are a component developer, a component supplier, again, we're talking about someone who's doing R&D here. They have come up with a component that makes an existing system work better. There's considerable case law out there saying that they may not be entitled to an injunction, and those suppliers are often far smaller than the system suppliers, the system operators that they are trying to license out. It's exactly that difference when litigation resources are abundant on the user side and they're not that abundant on the innovator side. That's where we get this result that just doesn't make sense as a policy matter. We're obviously disincentivizing innovation by entities that do a lot of R&D, and they monetize it through licensing or through component sales. So I just wanted to add that nuance.
Yeah. Thank you, Jonathan. Now, of course, Jonathan and Kristen have been primarily talking about the United States. So, Urshka, why don't you kind of expand out the focus here a little bit by putting this in the context of the global innovation economy in which the United States and its innovators participate.
Yeah, sure. Thank you, Adam, and thank you for having me here. I think Jonathan and Kristen have covered a lot. Maybe just give me a little bit more details on how a predatory infringement happens in practice, and then explain why do we care, both in the US but also globally. So as Jonathan mentioned, predatory infringement is one term I often use in my research. I use the term patent holdup. Call it also patent theft, patent trespass, IP piracy. But basically all these terms refer to an opportunistic behavior of an infringer of a patented technology. And that opportunistic behavior can take different forms. For example, the infringer might simply refuse to engage in any form of discussion with the patent holder, refusing to answer the notification of infringement and even to talk to the patent holder. Alternatively, the infringer can talk to the patent holder, but just use a variety of practices to delay the execution of a license agreement. Or in some extreme cases, the infringer even says, I will not execute a license and I will not pay a royalty until forced to do so by a court. And regardless of the strategy that the infringer adopts, the ultimate goal of this type of behavior is to delay, reduce, and sometimes even avoid the payment of royalties for the use of a patented technology. So then the question is, why do we care? Isn't this a dispute between the two companies that courts will eventually solve? So why is it important from a policy perspective? And I think it goes back to what Jonathan said. Patent holdup has detrimental effects on innovation and consumers, so is bad from the society more broadly. And that's because by hindering the ability of a patent holder to be compensated for its innovation in a timely manner, patent holdup undermines the ability of innovators to keep investing in R&D. And of course, patent holdup is bad for all companies, but it is particularly bad for smaller companies that are not vertically integrated or part of a conglomerate, because as Jonathan research has explained very well, these companies can rely on other mechanisms than patent protection to monetize their invention. They can sell products that include the price of their technologies. They can offer them their innovation for free and then sell products or services in other markets. But small companies often do not have these resources to be vertically integrated or participate in other markets. So the only way for them to monetize their inventions is to rely on a patent system. And when this patent system is not reliable, they can simply not compete in innovative markets. So if we want a diverse innovation ecosystem where both small and large companies can compete, then we need a reliable system of patent rights. And that's go to, okay, how do we achieve that? How do we discourage companies to engage in patent holdout? And that's where the policy perspective comes in. We need to create an incentive system that encourages companies to engage in voluntary license negotiation and pay for royalties upfront rather than wait to be forced to do so by courts. And I like to think of an example of a train, right? If the ticket to ride the train is $50, but the fine that you pay if you don't have a ticket for the train is $50, then we can see how a lot of people would simply choose not to buy a ticket and just pay the fine. And in the patent system, it's very similar, right? If you decide to infringe the technology and not opt to obtain a license, and the consequences of doing so is exactly the same as the payment of a royalty that you would have to agree in a voluntary license agreement, then I can see how many companies would just not enter into a licensing agreement. So basically here, the policy goal is really to create an environment where companies have an incentive to enter in voluntary license agreements. And that's true for the United States, and that's true globally.
Great. Kristen, coming back to you. So, you published widely on the issue of predatory infringement, and and its impact. And some people might be a little confused because they might be looking out at the world today and saying, we have an amazing world of all this incredible technological innovation. We have our smartphones and our mobile devices and all these other incredible achievements that have been brought to us by the patent system. So can you tell us perhaps why predatory infringement has become more prevalent in recent years?
Yeah, sure. I mean, there's certainly a number of reasons. One of the reasons is the rise in standardized technologies. All of the technologies that you listed off just now are heavily based on technology standards, and technology standards come along with the idea of standard essential patents. And those are the patents that I mentioned earlier that are one of the two primary groups that are unlikely to get injunctive relief if infringement is found in the court. And as Jonathan mentioned too, the components, again, the technologies that you mentioned, the great technologies that we have right now and love to use are the very same ones where we're seeing the types of patent owners that are unlikely to get injunctive relief. So I think there's a relationship between the really great technology we have and then the fact that predatory infringement is on the rise because of how those particular industries are built out. I think also too is the difficulty of showing willful infringement, because one of the main objections sometimes by the folks who call this efficient infringement. This is efficient infringement according to some folks because this way we can take it out of the negotiation situation. Chances are these patents won't even be found valid. So it's just easier. It works out better. What this does is it puts a lot back on the court system, but it also, one of the things that efficient infringement proponents say is, well, if this is really truly a problem, it'll be taken care of with willful infringement. And the problem is that the law surrounding willful infringement makes that incredibly difficult. And so willful infringement isn't an option to solve efficient infringement or predatory infringement because the difficulties involved in the standards for proving willful infringement, and also the potential remedies for willful infringement are subject to the discretion of the district court. And so the last thing I want to say about this is that these groups, the patent owners that are unlikely to get injunctive relief and then are going to be more likely to be subject to predatory infringement are the same groups that are sometimes disliked by the mainstream. And so when they appear in court, the court is already coming in with a negative viewpoint. And even if they do find willful infringement, they're unlikely to get the extra remedies that are available because those are discretionary at the hand of the district court. And so if, for example, it's a patent licensing firm, everybody's heard in the news how bad patent trolls are. We have a predatory infringement situation. Willful infringement is pled. Even if willful infringement is found, which is going to be unlikely, the district courts can be like, well, you're a bad actor too, because you're a patent troll, and so therefore we're not going to enhance the damages. And then we end up in the same situation that causes predatory infringement from the get-go, which is the royalty rate that they end up paying at the end of the day is going to be probably lower than, and definitely not enhanced by willful infringement. And so that's why I think it's on the rise.
So, yes.
May I just jump in just with the data point? So there was, a few months ago, there was a study that was published by Markham and examined data about US patent infringement lawsuits in the last 20 years. And it really speaks to what Kristen was saying about how difficult it is for patent owners to obtain effective remedies in the United States. And basically this study finds that after eBay, so after 2006, the number of permanent injunction has fallen sharply. I believe so the study excludes the fall judgments and finds that between 2008 and 2012, there were 80 injunctions issued. And then they look at 2018 until 2020, and there were only 36 injunctions issued, so less than half. Then the study also finds that the median damage award has been decreasing over the last 15 years. And they found that enhanced damages are awarded in about 20% of the cases. So that speaks to the situation that Kristen was describing, right? Decreasing availability injunction, decrease in damages, and fairly limited availability of enhanced damages. So it's really not a system that encourages voluntary execution of license agreements.
Yeah, so and this new study really does bring some data to these discussions and debates, and some recent data as far as I'm aware, because there hasn't been a study of patent litigation released in for many years. And this one was, I think, released this past April on World IP Day, if I recall correctly. So Jonathan, similar to Kristen, you have also published extensively on predatory infringement and the innovation system more generally. I've published a book, and I highly recommend to the people listening or watching this to Google, in fact, Kristen and Jonathan's work, and to download it and to read it. So what do you think, given the facts that Urshka just gave us and the additional information that you provided and Kristen provided in the discussion so far, is the best legal or policy solution to deter this kind of opportunistic behavior that is resulting in patent theft, predatory infringement, or as the wonks like to call it, efficient infringement?
Sure. Well, the simplest fix would be a legislative fix, and that would be restoring the presumption of irreparable harm once the patent owner has defendability shown infringement. And just to make super clear for our audience, this is not a trivial task to make that showing. It's not as if this fix is going to allow you to walk into court and get an injunction whenever you feel like it. That's a significant undertaking, and it would be issued once those two vital points have been demonstrated. This fix, in fact, was made to the Trademark Act only a few years ago. And the reason why that happened is that courts were not only reading eBay expansively in the patent area, they were starting to apply it to other IP rights like trademark, which are not even mentioned in the eBay opinion. And trademark owners correctly observed that this would pull out the property rights underpinnings of the entire trademark system and all of the licensing and other transactions that trademarks are based on. And this legislative fix was made by Congress. It was not especially controversial, and that's the simplest way to address this problem. The other point I would make is that this fix should not be controversial. I've searched for cases going all the way back to the early 20th century, and until eBay, I could not find a decision, perhaps one's out there, but I could not find a decision in which a court held, except perhaps in cases of a public emergency, that once you demonstrate validity and infringement, you do not get an injunction. You always got an injunction. Now, courts were often very tough on showing infringement or defending validity, but if you did that, you got an injunction. So this fix is simple. It's not controversial. It's just restoring a century plus at least, or Adam can explain why it's a centuries old practice in the common law tradition. And so that's really the easiest way to address this.
Yeah, since Jonathan prompted it, I have a study coming out of 19th century remedies analysis and injunctions in patent cases. And yes, but how Jonathan described the 20th century is exactly how they also approached in the 19th century. Once you had a showing of infringement of a patent that was deemed to be valid and survived patent validity challenges, you had a presumption of an injunction, and it was often awarded as a matter of course, and a vast majority of cases, almost 100%. Very, very common for it to occur.
And Adam, I just wanted to add one more thing. I think it's very reasonable. Someone hearing this may say, yeah, but if we go that way, then we're going to get all of these other non-meritorious lawsuits are going to come into the system. So the end result may not be what we intended. I think that misunderstands the toolbox that a federal judge has at their disposal in order to deter and penalize the opportunistic use of this particular cause of action, as they do in a myriad types of other causes of action. There are lots of tools that courts have, and I'm sure that they would use in order to deter opportunistic infringement suits.
Yes, exactly. Such as sanctions and even sometimes equitable dismissals of lawsuits for abusive or strategic behavior and abusive process. Exactly. So, and it's not, and that's a really good point to make because it contextualizes what sometimes seem to be unique patent problems within the broader litigation system in which the patent litigation is occurring, to show that how judges address strategic and abusive behavior in other contexts can be and has been applied into patent litigation itself. So, Kristen, you've done some research on the impact on predatory infringement on licensing. That's one of the issues we wanted to talk about a little bit more directly today. And Jonathan has also done some research on these issues. So, what has been the impact on on the value of patented technologies that are deployed through licensing in the innovation economy as a result of the practices of predatory infringement?
So the first thing to know is it's really hard to measure a lot of this because negotiations are secret, licenses are generally secret. And so what we can measure and what we can see is oftentimes inferential. However, there's some good information that's starting to come out, which is letting us make some conclusions, draw some conclusions from the data that we have. It warrants more study, but there's definitely some data that we're starting to see that lets us see the negative impact. And so the one I'd like to talk about today is actually one that I published with Hudson. So feel free to go out and grab that paper because it's really good and I wrote it. But there was some data that was provided by a study that AUTM did about U.S. licensing activity between 1996 and 2021, which is a nice range of data because it captures both the data before the eBay decision and after the eBay decision. And what the AUTM data shows, or Autumn, what the Autumn data shows is that before 2006, the rate at which exclusive licenses, meaning licensing to one other party, and non-exclusive licenses, meaning licensing to multiple parties, both were happening at approximately the same rate. And so what we see after 2006 is that exclusive licensing, again, licensing to one particular party or technology, seems pretty stagnant, doesn't change very much at all, maybe even goes down a little in some cases. But what is interesting, and the piece of data that we can draw some conclusions from, is after eBay, the rate of non-exclusive licensing to multiple parties of your technology grows greatly, skyrockets up. And so why this matters is that non-exclusive licenses are usually viewed as less valuable. They garner less money for the patent holder because people are not willing to pay as high a rate if they know that their competitors are also able to license the same technology. That's the whole gist of a non-exclusive license. Whereas an exclusive license, you know you are the only party other than the patent holder who's going to be able to use that technology, and that creates a different impact on the market for your products that you put out. So this change, this idea that non-exclusive licenses are happening more frequently than they were before eBay, shows that the overall value of licenses is probably being devalued. The overall value of patents is probably being devalued. Parties are more inclined to choose a lesser valued license, pay less for their license. And so that's a real problem. And it all goes back to eBay, and it all goes back to the predatory infringement, right? Because why would you pay for something where if somebody else, another party, engages in a predatory infringement, they're not going to be stopped by the courts. So even if you pay for an exclusive license, if another party goes and engages in predatory infringement, all of a sudden now you have to compete with them, despite the fact that you paid to be the only party using that technology. And so it's creating this situation where, again, the lower value licenses are becoming more prevalent, and that's a real concern.
Yeah, I wanted to just clarify on that point. We talk a lot today about the role of patents, SEPs in the wireless space. This is really just a continuation of licensing practices with many different holders and many different device producers that you really see from the very start of the consumer electronics industry. This is sort of the plumbing behind the wall that no one sees, but it makes everything work. And in particular, it does two things that are really good for consumers and for markets. The first thing that it does is that when you have an industry where the R&D is being monetized through licensing, okay, and what I wanted to clarify, because in the consumer electronics industry, the licensing is happening on the basis of standards, okay, and the R&D innovators are monetizing that R&D through non-exclusive licenses, okay, and all of that is anchored in the patent right. So why is this so great for consumers and markets? Because it lowers the entry barriers at 2 points in the market. It lowers entry barriers for innovators who don't have to vertically integrate into production. But almost more importantly, it lowers entry costs for the device producers who all have access to the same technology through those non-exclusive licensing networks. And the R&D innovator wants it that way. They want to distribute that very broadly. And the reason I wanted to bring this up was, one, to emphasize that the licensing in the IT space is typically non-exclusive. But I also wanted to leave the audience with a thought experiment on this question. Imagine that we take this world, this is the world we live in now, and we abolish patents. Okay, what you just have done is that you have destroyed the underpinnings of the licensing-based business model. Why do we care? Well, because the R&D innovators are now going to only be able to monetize R&D through a vertically integrated corporation. That means we're going to have a couple of really big silos, a couple of really big walled gardens. This is a subtle point, but the point is that as we make patents more secure, easier to enforce, we actually lower entry barriers and we make markets more competitive. And this all happens through non-exclusive licensing anchored in that patent right.
Excellent. So since Kristen has mentioned it, I just want to highlight the title of her policy brief that was published by the Hudson Institute. It's called "The Loss of Injunctions Under eBay: Evidence of the Negative Impact on the Innovation Economy," released this past February of this year, and highly recommend people to download it. It has some great data in it. Speaking of data, and I'm glad that we're talking about data now and empirical evidence of this phenomenon of predatory infringement. Urshka, you did an empirical analysis of predatory infringement, and what did you find as to whether this is a real phenomenon that's occurring in the real world, or is it something that is just only described in the abstract and in the theoretical framings of commercial practices?
Yeah, so the short answer is yes, it is a real world phenomenon. Basically, so with my co-author, Kirti Gupta, we did one of the first comprehensive analysis to determine whether patent holdout actually occurs in practice. And although patent holdout is in no way limited to a specific sector of industry, we focused on standard essential patents. And that was, first of all, a practical approach because it allows us to review a smaller set, still large, but a smaller set of data, but was also like a sensible solution to focus on standard essential patents because this is the context where patent holdout and patent holdup are often discussed. And basically what we did, we examined court decisions that span for a decade from 2012 to 2022, and we looked at 5 jurisdictions: US, UK, Germany, the Netherlands, and India, which are among the most important jurisdictions where we see litigation related to standard essential patents. China is also another one, but there were some issues with access to data. So that's why we focus on these 5 jurisdictions. And we try to identify court decisions in which the court has found that the infringer engaged in patent holdout, either using explicitly this term or saying, that the infringer was an unwilling licensee, negotiated in bad faith, or in the US, for example, that there was willful infringement. And we did find quite a few cases of patent holdout. I believe there were over 50 cases. And just to clarify, these are not parallel cases. These are unique cases of patent holdout, meaning that we excluded all cases, where there was litigation between the same parties, but in different jurisdictions, or between the same parties, same jurisdiction, but different appellate level. So basically, there are more cases in which the court has found patent holdout, but these 54 were unique cases of patent holdout. And of course, our empirical analysis, it's focused only on adjudicated cases, so where the dispute reached a final stage. But of course, this doesn't reflect the full scope of how patent holdout occurs in practice, because it is possible and actually highly likely that an infringer engages in patent holdout, but then the dispute is solved before it reaches final adjudication. So long story short, to say, yes, we did find that there is ample empirical support in court decision about the existence of patent holdout. So yeah, it is. It's not just a theoretical concern; it is a real world problem.
Yeah. And kind of continuing the focus now again on kind of the global innovation economy and global patent litigation more generally. So going even beyond the United States and the specific enforcement of U.S. law under eBay. Jonathan, you've done some work on the importance of reliable and effective patent rights for U.S. global competitiveness more generally. Could you talk a little bit about this and how predatory infringement is playing a role in this context?
Yeah, sure. Since the enactment of the TRIPS agreement, it's been U.S. policy across administrations to work to get agreement and compliance around the world on a basic fundamental baseline of intellectual property enforcement. And there's two reasons why that makes sense. It makes sense for the entire world because just as it's not controversial to say that markets require property rights to form, well, so too, when you're talking about markets in technology across countries, by having that agreed upon baseline with perhaps country-specific variations surrounding that, but an agreed upon fundamental baseline of IP expectations, you allow markets to form on that basis. You allow supply chains to form, and your economies around the world develop more efficiently, and the consumers are ultimately the benefit of that. There's a second reason why that makes sense specifically for the US, and this is particularly salient at the moment since a lot of the IP policy issues now have a global competitiveness or a national security aspect to it. So it's well known that the US has had for a long time a significant trade deficit versus other countries, especially China. It's not so well known, perhaps, that the US has a very significant IP trade surplus, right? That means that US IP owners are getting a lot more money coming in than going out, right? And that simple fact should tell you that it is in US national interest to have a robust IP system that enables innovators to monetize that innovation and to monetize it any way they want, right? Because we don't know, when we're talking about policy, we don't know what's the most efficient way to monetize innovation in a particular market. There are lots of ways to do it, right? But when we make patents weak, we don't enable the licensing-based monetization model to operate, and that's not good for the global innovation economy. In particular, it really doesn't make sense for the U.S. innovation economy. We're really good at design. We're not in manufacturing business so much anymore, but we're really good at design. And if you're good at design, you're an innovator. You should be pushing for secure IP rights.
Yeah, exactly. And kind of continuing the theme of making sure that we have data to back up these points. I would direct people to another Hudson policy memo that was recently published, titled "The Western Innovators of the Mobile Revolution: The Data on Global Royalty Flows to the US and Europe and Why It Matters," which reinforces Jonathan's point that global royalty flows are coming to the United States and to Europe because it is US innovators and European innovators who've created these technologies, creating the positive international trade flows as distinguished from the trade deficits that we normally hear about in other industries and other sectors of our local domestic innovation economies. Last but certainly not least, we've been talking a little bit about the global context here and the importance of U.S. and even European-based innovation, especially in the context of patents and patent licensing. And there's been some recent developments in the European Union with respect to the patenting of these standardized technologies that go by the term standard essential patents. The EU is currently considering adopting a massive new regulatory regime that will impose price controls on royalty rates of licensing of these patents that are that for which patent owners have agreed to FRAND licensing, as well as other regulatory restrictions. Urshka, how does this proposed regulatory regime impact predatory infringement? Will it exacerbate it? Will it address it? Because the proponents are saying it's going to resolve a lot of these litigation frictions that we see. Is that the case, or is it actually going to make the situation worse?
Yeah, I do think it's not going to make the situation better. But let me take a step back. So the trend that we have seen in respect to SCPs is not just limited to the EU. We have seen across the globe, several agencies, have looked at various measures that they could adopt to improve the efficiency of licensing of standard essential patents. In the US, we saw in 2000, there was the withdrawal of the policy statement on standard essential patents. We have seen the USPTO has been focusing on promoting WIPO as a center for dispute resolution. In the UK, there was a launch of the SME Hub, which is kind of a center that provides various informations related to SCPs. And these were all non-regulatory measures aiming at increasing efficiency of licensing of standard essential patents. Europe has adopted a different approach, as you said, a regulatory approach, massive regulation that would change practically both negotiation and enforcement of standard essential patents. And what I find particularly noteworthy is that the regulation does not include any measure that is directly targeted at addressing the problem of patent holdout. We can hear rhetorics about that, but there is no measure that we can point in the regulations like, yeah, this is aiming to address patent holdout. And rather, there are definitely some procedures envisioned in the regulation that could exacerbate the problem of patent holdout. That is because, as currently written, the regulation does not include the necessary safeguards that would prevent bad faith implementer from misusing the procedures to simply delay the payment of royalties. So a good example is the FRAND determination procedure. We have heard judges expressing concern about delaying the access to justice exactly because of that, because, having access to justice, to remedies, is important to avoid patent holdout. And again, patent holdout is something that regulators should care about. And, the entire empirical evidence that we have gathered shows that, if you want to increase efficiency in the licensing negotiation for SCPs, it is critical to adopt measures that mitigate patent holdout. And it is important for regulators to do that, and we haven't seen it done yet. Yeah,
it's a situation where it seems like the proposed cure for the disease is actually more disease, and that's never going to be a good situation. This has really been a really interesting, fantastic, and as we always like to promote, database, data-driven discussion about the kind of current state of patent licensing and the threat to growing innovation economies and new innovation posed by the practice of predatory infringement, this kind of strategic opportunistic behavior that's engaged in by people who choose to infringe as opposed to licensing the property rights that they are taking from others, oftentimes others who have invested a lot of money to create it. We've directed people to a lot of the research done by Jonathan, Kristen, and Urshka, and I hope that people will take advantage of that and take advantage of our interconnected world and these new credible technologies and access their research and learn more about these topics, especially those who are on the Hill and are engaging in policymaking so that they can themselves engage in evidence-based policymaking. Thank you very much. I hope everyone has a good day.